read the briefs. We're prepared to go, and you have 15.
Okay, thank you, Your Honor. Judge, thank you, judges. I guess I'll just jump in here. In this particular case, we're dealing with Jeffrey Straughan, a defendant convicted of various offenses at jury trial in Summit County Common Pleas Court. I've detailed in the brief, as the court is aware, you've read the briefs, five arguments or five assignments of error: sufficiency, manifest weight, plain error, prosecutorial misconduct, ineffective assistance, and cumulative error. A majority of these errors deal with due process rights under the 5th and 14th Amendments, and also 6th Amendment trial by impartial jury, confrontation of witnesses, and effective assistance of counsel as well. So essentially, just jumping in here, I think in regards to the discharge of the firearm count specific to the sufficiency of the evidence claim, I'm dealing with an argument that is in regards to essentially one element of that offense, that being a firearm discharged upon or over a public roadway. That I think the language in the statute, if we're dealing with something that happens upon a roadway, the shooter would have to be in the roadway or on the roadway for that to apply. Over the roadway would imply that someone is shooting a projectile, obviously over a roadway. In this particular case, we have a situation where the prosecution did not present any evidence in relation to where the final resting place of the projectile went. Evidence was presented that the defendant went back, Mr. Straughan went back later, and states that he found the projectile, but it was in the parking lot of the location of the offense. That would indicate that it never traveled over the roadway. I think that based upon that, when the jury deliberated, they lost their way. I believe that the jury did not have enough factual evidence to properly infer that that was a completed crime. The prosecution asked at one point for an adjustment to the jury instructions that would include an attempt on that particular offense. And the prosecutor specifically stated if the jury believes him that the bullet didn't travel into the road, he couldn't have committed the offense.
Counsel, go ahead, Judge. I'll defer to Judge Hensel. Go ahead.
Wasn't there at least one of those 6 witnesses that did testify that the bullet would have had to go across the road based on what she witnessed happened at the scene?
There were actually 2, and I think that statements of would have had to go or could have gone, I don't think that is a definitive for a jury to find that it actually did go across the road. I think that's a supposition or a projection, if you will, on the part of that witness. There are many times in regards to these types of cases where a person firing a handgun may be aiming it at an individual or a car or a building, and they press the trigger in a fashion that the muzzle is pointed down and ends up they miss the target completely. So just because a firearm is pointed in a certain direction does not mean that the bullet or projectile will go and follow that direction as well.
Let me follow up on that then. My understanding was the defendant testified that he was shot as he tried to cross the street, and the manager of Burger King testified that the victim was running away across the street. Are you saying that the bullet hit the ground and did not enter the street? Because I thought there was also testimony that there was gun residue on some bullet holes in his shirt.
That is correct, that there was gunshot residue. Now that, depending on the distance from muzzle to target, could indicate that anyone within a 6 to 10 foot radius of that firearm, depending on the direction it was pointed, could have a gunshot residue on their clothing.
Yeah, I was interested, was there any testimony developed in that area, distance for gunshot residue?
Not directly on this. Well, there was the defendant, Mr. Straughan, mentioned that they were face to face when he pulled the firearm, drew the firearm the second time and actually fired, because he drew it twice. There were two actual,
right,
within the total confrontation, there were actually two drawings of the firearm. But he mentioned some distance. He was not clear on how far they were from each other. I think victim and Mr. Straughan both stated during their testimony that they were facing each other as well. Various witnesses said, again, as you pointed out, Judge, some witnesses said, well, this guy was in the street, he was running away, had his back to him. Other witnesses said, no, they were facing each other. What happens in these cases is everyone's perception depends on their stress level. When you have someone firing the firearm, their stress level is a certain level, and when they're in the position of firing that firearm, their mind only records certain things. The person being shot at, again, will record certain things. If you have someone who witnesses this, if they even blink, that may be a second-long interval where they appear to see something that they believe happened, but it was not the reality. And moving on from there, I think that gets into the manifest weight issue. Because of all of these differing views in situations, I think that the weight of the evidence was such that it was questionable as well. And then moving forward, if I may, in regards to both the plain error and the ineffective assistance, we have very similar arguments, but they were split for purposes of judicial economy here. The major issue in that respect involving the court and the jury, I think, is the vague jury instruction in regards to self-defense. Essentially, we have a situation where a new law has been passed recently, went into effect last year, regarding self-defense, changing the burden of proof from the defense to the prosecution, and requiring that the state, depending how it's written, either prove or disprove certain elements in relation to self-defense. The Ohio Judicial College has developed new instructions regarding that. There was a reference to that in my brief, or the appellant's brief regarding that. And I think that based upon what was presented to the jury, and specifically, I think the vague portion is in the jury instructions, it instructed the jury to find the defendant guilty if they found that self-defense didn't apply. I think that the problem with that particular instruction in the vagueness aspect of it is that if there's a four-pronged test for self-defense, and under the model instructions as presented in the appellant's brief, one of those prongs needs to be proved or disproved beyond a reasonable doubt, depending on how it's written. If the jury doesn't know what they're supposed to look at through a vague instruction, I think that they come to a determination that cannot be trusted. And I think that's the problem in part of this case as well. We believe that that's a plain error based on the three-pronged test in State versus Tench, that an error exists, the error is obvious or plain, and it affects the substantial rights of the defendant. In this case, due process as well as the right to impartial jury. I think that when vague instructions are given, the jury can step into a situation where let emotion or feeling get into things, and they end up not being impartial at that point. In regard to the plain error, we would have to show that the outcome would have been different. This particular jury instruction, the vague issue, was not objected to by counsel. We believe that that creates a situation where ineffective assistance applies. And in that realm, the standard is not necessarily, is not whether the outcome would have been different, but whether there's a substantial likelihood that the outcome would have been different. And I think the 11th District Court of Appeals dealt with that recently in State v. Thomas, that's cited in our brief. And they effectively say that the defendant did not receive a fair trial because the jury did not deliberate with a complete set of instructions. And I think that in this case, both on the ineffective assistance angle as well as the plain error doctrine, the jury has to have the proper roadmap to make a decision. If defense counsel fails to object to that or fails to ask for an appropriate instruction, as happened in the 11th District with State v. Thomas, citing State v. Lewis, I think the failure to ask or the failure to object triggers ineffective assistance. I think it's plain error when a vague clause is used, and this is something that I've gone in depth in that. Moving forward.
One quick question. Did either side or both sides submit proposed jury instructions on that issue, self-defense? And the second question would be, did the judge utilize the Ohio jury instruction on self-defense in instructing?
In regards to your second portion of the question, the Ohio jury instruction, at the time of this brief being written, had not officially provided a new jury instruction involving the new law. What is provided and what was cited in my brief was a proposed jury instruction from the Ohio Judicial Conference in regards to that. So that's something that, you know, in fairness to the court, it may not have existed. However, with the change in the law, it could have been formulated by the court or by the parties in conjunction with the court. Now, again, if defense counsel didn't ask for that, you know, the 11th District in their recent decision, State v. Thomas, has stated failure to ask for a instruction regarding castle doctrine is ineffective assistance. That would end in the result of the trial, a reasonable likelihood the result of the trial would have been different if that had been applied. That is what we are arguing here. Very similar, however, in this case, obviously, we do not have the benefit of the castle doctrine because this was out in the open in a public parking lot. So it can be distinguished slightly, but if we're talking about jury instructions and jury instructions, that is a comparison of apples and apples, I think.
Counsel, you only have about 1 minute left, so I just wanted to let you know that so you could argue whatever you wanted to real quick.
Okay. Thank you. The other matters involving hearing impairment, I think it's important that that be touched on. Sixth Amendment under State v. Shyam requires the court grant an evidentiary hearing when a credible claim is made. No evidentiary hearing was had. However, there was some subject of this brought up in court, but it was not a full evidentiary hearing. The other matter is the Remmer hearing, State v. Owens, 9th District. You've already previously stated when alleged outside contact with a juror has been made regarding a subject matter of proceedings, the trial court must conduct a hearing with all parties to determine the circumstances, impact upon a jury, and whether it's prejudicial. In that case, in this case, that did not happen. I think that could have been done sua sponte by the court. It should have been requested by defense counsel. In personal experience I've had as a prosecutor and defense attorney, where the court has requested it, I've requested that as a prosecutor in prior cases. In regards to the prosecutorial misconduct, we extensively discussed brandishing versus open carry. I believe that in this case, the senior prosecutor, junior prosecutor, I don't think did anything. senior prosecutor created an unfair atmosphere that prevented Mr. Straughan from getting a fair trial based upon his mischaracterization of the law and using that blue gun training tool and pointing it at him, pointing it at the defendant while he was on the stand. I think that that created some significant problems as well.
Okay, thank you, counsel.
Thank you, Your Honors.
We will take the matter under advisement, and we will issue a written opinion, which will be sent to you and to the state, obviously. And then we also release on our website in the Supreme Court. Thank you again, and glad to see you. And this was the only thing we have argued today, so.